A group of Chinese citizens residing and working in Florida has filed a lawsuit against the state, challenging a recently enacted law that prohibits Chinese nationals from purchasing property in certain areas. The law, which also extends to citizens of Cuba, Venezuela, Syria, Iran, Russia, and North Korea, specifically targets properties within 10 miles of military installations and other critical infrastructure. The American Civil Liberties Union, ACLU, has joined the lawsuit, arguing that the law unfairly discriminates against Chinese and Asian individuals and violates the Constitution and the Fair Housing Act. According to the ACLU, the law will have a significant chilling effect on property sales to Chinese and Asian buyers who are legally eligible to purchase real estate. The organization contends that there is no evidence to suggest a national security risk arising from Chinese citizens buying property in Florida. Furthermore, the ACLU argues that the legislation perpetuates housing discrimination based on race and ethnicity, placing undue suspicion on anyone with a name remotely associated with Asian. The strained relationship between the United States and China, characterized by escalating tensions over security and trade, has heightened concerns about foreign land ownership. Russian, Iranian, Cuban, Venezuelan, or Syrian origins. Recent events, such as the passage of a Chinese spy balloon across several states, have amplified long-standing worries about foreign entities acquiring land in the country. Governor Ron DeSantis, a Republican and potential presidential candidate, signed the bill into law on May 8, aiming to address these concerns. However, the governor's office has not yet responded to requests for comment. Scheduled to take effect on July 1, the law imposes severe penalties on Chinese nationals who purchase property in restricted areas and on individuals or real estate companies knowingly selling to restricted buyers. For other targeted nations, the penalty is a misdemeanor offense for both buyers and sellers. The restrictions encompass military installations, airports, seaports, water and wastewater treatment plants, natural gas and oil processing facilities, power plants, spaceports, and telecommunications central switching offices. The ACLU argues that the law effectively establishes Chinese exclusion zones governing significant portions of Florida, including densely populated and developed areas. In an effort to enforce compliance, individuals on the restricted list who already own property near critical infrastructure must register with the state. Failure to do so may result in fines of up to $1,000 per day, and additional property acquisitions are prohibited. The law also grants the state the authority to seize properties owned by violators. The issue of foreign ownership of agricultural land has also gained attention, with a 50% increase in the number of states implementing restrictions this year. As of the beginning of 2023, 14 states had laws in place restricting foreign ownership or investments in private agricultural land. Since then, several additional states, including Arkansas, Idaho, Montana, Tennessee, Utah, and Virginia, have enacted similar legislation. Micah Brown, a staff attorney for the National Agricultural Law Center at the University of Arkansas, describes foreign land ownership as a political flashpoint. The recent surge in state laws targeting land ownership by foreign entities can be attributed to high-profile cases involving Chinese-affiliated companies purchasing land near military bases. Air Force expressed concerns about national security threats posed by the Fufeng Group's planned $700 million wet corn milling plant near a base in Grand Forks, North Dakota. In one instance, the U.S. Similarly, Texas responded to a Chinese Army veteran and real estate tycoon's purchase of a wind farm near an Air Force base in the state by banning infrastructure deals with individuals connected to hostile governments, including China, in 2021.